opportunity to respond. Thank you.
Thank you, Counsel. All right. We will proceed now to our second case, Stephen L. Bartlett versus State.
May it please the Court, Your Honors, I'd like to reserve 3 minutes. For the record, my name is Joseph August Fisher III from Leventhal and Slaughter, here on behalf of the appellant Stephen Bartlett. This case is about a legitimate home builder who did not have the intent to steal his customers' money. The trial court in this case incorrectly denied the appellant's judgment of acquittal based on the state not being able to refute his innocence of hypothesis, which was he had been a successful home builder for more than 10 years. Not a single complaint by the Florida Department of Building. 2005, he goes from building 30 homes a year to roughly 150 homes. The real estate market's in overdrive. He bites off more than he can chew. The facts of the case are he put in almost $2 million.
We know what the facts are, Counsel, but you agree that he commingled funds?
Commingled funds? Yes. Did he run his business? I also agree that he didn't run his business properly.
Yeah.
With certain respects to accounting.
You also agree that he collected money but failed to pay his subcontractors?
Sure, that's a possibility.
It's not a possibility.
Well, sure.
It's specifically testified.
Okay.
You agree that his own employees told him he should not take on any new housing because they had been unable to get the older housing done?
Yeah, he bit off more than he could chew.
You agree that he lived a rather extravagant lifestyle?
Sure.
You agree that he used his company's money for personal items?
I believe he paid himself out of his own company. He didn't separate his bank accounts.
Oh, yeah. I mean, he took trips to Las Vegas from the company account.
Sure.
And you agree that at least 97 victims, some of which paid over $150,000 that didn't get out of him, and some of which paid over $200,000 and got little or nothing out of it. Also, you agree that happened as well?
I believe that happened.
Your theory is that he was just a bad businessman.
Sure.
When 97 people paid him large sums of money, and he got nothing out of it.
Well, he was shut down by the state. He pulled, in a 2-year period, over 215 business permits. Someone who was running a Ponzi scheme would have, there's no badges of fraud. He doesn't have a double set of books. He was actually building houses.
He had no set of books. He didn't have a double set.
You have repeat customers. A guy who's trying to rip off people wouldn't have repeat customers building houses. He actually was a home builder.
The only key is whether or not that was sufficient evidence to contradict his theory of innocence. I have a hard time seeing that it's not.
I think when you look at the amount of money he put into the business, and yeah, there was accounting issues and whether or not he went to Las Vegas and lived an extravagant lifestyle. Well, at one point, he was actually building around 40 houses a year. And for a 10-year period, he ran this business. If someone were going to set up a fraudulent business, you would see it after hurricanes come through. Someone might set up a mold testing company. This is different in this case because he already had a legitimate business. Now, was he a jerk and did he not call customers back? Yes. And I think the line of cases I cite in my brief about the contractor and building cases, Crawford, Martin, Stramaglia, Benitez.
Isn't your main issue that the state didn't prove intent?
Yeah, that's my main issue, sir.
And getting back to, what the defendant's employees and associates testified to at trial, specifically Jeff Collender testified that he should stop taking on new homes because he couldn't finish the ones that he had already started. And the reply from your client was, well, just don't tell me how to run my business. So at that point, he knew that he couldn't complete the projects. He was taking money knowing he couldn't complete the projects and had been warned to stop, and he didn't.
He was.
Why isn't that sufficient evidence of intent?
Well, he shut it down, but he shut it down too late. He stopped taking new contracts in 2006. When he was shut down, he had around 30 homes that were within 45 to 60 days of completion.
I know, but the jury heard all of that evidence and heard the testimony of Mr. Collender. They heard the testimony of Diane Tinian, who also stopped selling homes and told him that he needed to cut back, and he didn't. And so the jury heard all this. And my question to you is, why isn't that sufficient evidence for the jury to say that, yes, he intended to take this money and not give them what they had contracted for?
Well, I think one of the problems with this case is the prosecutor in this case argued negligence. And when you look how this case starts from his opening statement, he says directly in here.
I know, but the prosecutor, your primary issue on appeal is intent. The state didn't prove intent. And my question to you is, the jury heard from Collender, the jury heard from Tinian, that they had warned him to stop, that he was taking money from these people and not giving them what they had contracted for, and he needed to stop because he couldn't complete the projects. He couldn't even complete the projects that he had already started. So my question to you is, why isn't that sufficient evidence for the jury to say, yes, he intended to steal this money?
Because that is an intent of theft. That goes to him being a bad business person. That goes to whether his performance was adequate or not. And that, to me, is a civil issue, not a criminal issue.
The testimony of these people was, don't take any more new customers on, don't enter into any more contracts because you're taking money and you can't build the homes. And they warned him of that, and he told them to stay out of my business and don't tell me how to run my business. That, to me, seems to be clear evidence that he intended to take this money, not give them what they had bargained for in exchange, and to take the money and just do with it what he wanted.
Well, it wasn't take the money and do so much with it what he wanted. He
was going to Las Vegas. He was making all these trips. He was buying boats and motorcycles.
Sure, and that was put in evidence. There's no question about it. But he was also running a business, and he was also finishing homes and building houses. Had he not been doing anything like Sewell, a Ponzi scheme, then I can understand where he had intent to take these people's money. He clearly ramped this business up too much and tried to take on too much and ignored his employees when they said, you need to slow down, don't take any more contracts, you've got too much going on.
So your theory is that none of this implicates intent at all?
Not an intent to steal from his customers. He was a builder. I don't think he intended to steal from his customers.
It doesn't make any difference what you think. What's important is what the jury thought. And my question is, you don't agree that whole litany of problems that he had, including taking money from 97 people that he couldn't build houses for, I mean, large sums of money, that doesn't amount to some evidence of intent?
I agree. It amounts to evidence of him being a bad business person, but not a thief. He was a home builder.
I didn't ask whether you thought he was a bad business person. I said, is that some evidence of intent?
Intent to steal?
Yes.
No.
Okay, that's where you and I disagree rather seriously.
I think his intent wasn't to steal. I think he legitimately thought he could build these houses. And he went and filed a bankruptcy, had a bankruptcy attorney tell him, let's put a plan together. He had a reorganization approved in the Middle District of Florida.
Well, before he filed bankruptcy, he gave a $60,000 check back to one of his friends and said, I know I'm going under. And so he was at least willing to protect his friends, but he wasn't willing to protect his customers. Didn't he give a $60,000 check back to a man named Zablosky or something like that?
Yeah.
And so he knew he was going under before he filed bankruptcy, and he knew that he wasn't going to be able to repay these people their money, and yet to protect his friend, he gave him a $60,000 check. So isn't that evidence that he knew before he filed bankruptcy that he had taken this money and with the intent not to fulfill the promise to build these people the homes as he had originally agreed to do?
I don't think his intent was not to fulfill the promises to build these homes. I think his.
But isn't that evidence that he knew before he filed bankruptcy that he had taken this money without?
Yeah, he paid off a subcontractor that he owed money to, and he didn't hide any of this. It was all disclosed. It was out in the open. It wasn't as if he was secreting money to pay off friends of his.
Well, obviously, if you're going to pay somebody a $60,000 amount and give them a check for it, it's going to be disclosed sooner or later anyway. That's kind of hard to hide, isn't it?
Yeah, it most definitely is. And I get back to there wasn't anything that was what you would see as a typical badge of fraud in a case like this.
Well, Mr. Fisher, it seems to me that many of the arguments that you're making are more appropriate for a jury than for an appellate court. I mean, our standard is to review the trial judge's denial of your motion for JOA. And the trial judge's standard, as I understand it, is there a facial inconsistency between the evidence viewed in the light most favorable to the state and the defense theory? Your theory was he's just a bad businessman. Their theory was he may have been a bad businessman, but he was also a thief, and that's evidenced by him treating the company money like it's his personal piggy bank, and them putting on scads of evidence to demonstrate how the money was commingled and used for all sorts of things that were unrelated to the construction. If there's a facial inconsistency between those two theories, and it seems to me that there is, doesn't it become the jury's decision as to whether they buy your theory, which is I'm a bad businessman, or their theory, which is I'm a bad businessman and I'm a thief?
In that sense, it does. But my argument is that the prosecutor didn't exclude his reasonable hypothesis of innocence in this case. Based on all the stuff that he had done, he had been a home builder for over 10 years. He did actually build houses, and he had repeat customers. He had customers testify that after he had already been charged, he continued and helped them with their houses and try to finish their houses.
Well, the trial judge is supposed to determine whether there's competent evidence from which a jury could infer guilt, and we're talking about the circumstantial evidence standard. Then it's up to the jury to make the decision as to whether the reasonable hypothesis has been refuted and rebutted. Isn't that the proper standard?
Well, I get back to...
And so that gets back to, well, the trial judge heard these witnesses testify that they warned him not to take any more new customers, and he did, because he couldn't complete the projects that he'd already started. He knows before he files bankruptcy that he's in difficulty, and repays a friend a $60,000 check, but doesn't attempt to repay anybody else any of their money. And so why isn't that competent evidence for the trial judge to say, okay, well, the jury could infer intent from that and leave it up to the jury to make the final decision?
I get back to the line of cases emanating from this court, starting with Brewer, going all the way up through Eisenhower and Siplin, and that he was negligent in how he ran his business, but he didn't have criminal intent to, when he got this money, to steal.
Well, those cases are distinguishable. You mentioned Eisenhower. I wrote the opinion in that case, and that was a case where the defendant did everything he could to comply with the requirement that he give the money away as he properly could, and he was thwarted. And so he made every attempt to do it, but was prevented not from his criminal intent, but by others from complying with the grant requirements. So that case is distinguishable. That doesn't. I mean, there was nothing here that indicated that this person was being thwarted by others.
And my argument is he was thwarted in that he took on too much. The real estate market was going through the roof. By the time it took to get materials and supplies, because everyone was building houses, spec houses, everyone wanted to be a developer, that the lag times, it continued and continued. The alleged victims in this case testified that they were given target dates. They were told that there might not be any progress on their houses for months.
Okay.
And I'm going to reserve this 2 minutes. I'm already past my 3.
May it please the Court. I'm Rebecca Wall, Assistant Attorney General, and I represent the state in this appeal. The state presented ample evidence to show, at the very least, that Mr. Bartlett intended to use temporarily the money that the victims paid Coral Bay to build their homes. And I think the state also presented substantial evidence to show that he intended to permanently deprive. If you look at what Mr. Bartlett did after declaring bankruptcy, not personal bankruptcy, declaring Coral Bay bankrupt, he sold motorcycles and put the money in a bank account he created in his daughter's name and used it to live on. He sold jewelry, used the money to live on, allowed the luxurious motorhome to be repossessed. Even assets that he used, Coral Bay assets, to buy personal items or items that he used for his own personal fun and activities, he either converted them to his own use later or let them just dissolve. The company, the scuba shop, the dive shop, he ran that, let that go under as well. He not only took these assets to clearly temporarily use them, depriving the victims of the use of this money to build their homes. But I think the state also presented evidence to show that he intended to keep these assets, because that's in fact what he did do. Testimony showed that between June of 05 and June of 06, only 9 homes were completed. Now, Mr. Bartlett on the stand said he didn't believe that was true, but he offered no evidence to contest that. He was a bad businessman, and he used the assets of the company paid for by the victims to build their homes for his own use, and he did it over and over and over again. Finally, between January and March of 2006, he withdrew over $200,000 in cash from Coral Bay accounts and couldn't identify where that money went. So he bled the last little bit of assets there were in the company at the very end. The state presented ample evidence to show that Mr. Bartlett intentionally took the assets of the company belonging to the victims who paid that money to build their homes for his own use, temporarily and permanently, depriving the victims of the use of that money. The state showed ample evidence of intent. Unless there are any further questions, the state asked the court to affirm the conviction.
Thank you, counsel.
Just to sum up my point I was trying to make before, is that I think this is a guy who had been a home builder for a long time, and he became obsessed with signing up homes and signed up way too many. I don't think all of a sudden in the middle of the night he decided, I'm going to be a thief and take money from my clients. And based on the amount of money he put back into the company, the fact that he did have repeat customers, and that this is something that went on for years without a single complaint, and then all of a sudden when the real estate market goes into orbit and he signs up
He may
triple
have
the
been a
amount.
good builder to begin with, and maybe his intentions were good to begin with. But then, he had been warned, and he knew before he ever filed bankruptcy that he was in trouble, and he continued to take on new customers because he needed the money to keep his business afloat. And I think there's sufficient evidence in this record to show that there was sufficient intent on his part to take the money and not give them what they had contracted for. And the jury made the final decision in this case. I mean, they heard all the evidence, they heard all the testimony. All the judge did was say there's competent evidence that the jury can infer guilt, which is intent, and the jury heard it all, and they made their decision. And he may have had good motives to begin with, but he didn't end up that way, I don't think.
And I think if given the chance, there could have been a different outcome. But as we saw, his business was shut down, and he had homes under construction. There was work done. That's all I have. Thank you.
Thank you.